All right. Good morning, everyone, and welcome to our default calendar. We've got 5 positions left, I think, and we will march through them. I'm going to go slightly out of order because I have a couple that may take a little longer and a few we may be able to knock out quickly. So don't panic if I skip over you. We'll touch on each of the 5 remaining ones. I'd like to start with Bell and Washington versus Applewhite. Do we have anyone here for that?
Good morning, Your Honor. Brandon Byers for the plaintiffs in the matter.
All right. Is Mr. Applewhite here? Oh, okay. So, Mr. Byers, as I understand it, your client was retained by Mr. Applewhite to do some work. He stopped paying, and I think you've already submitted, or your firm representing that firm has submitted a proposed order. I just wanted to understand the attorney's fees amount. I think I'm thinking of the right case.
Yes, Your Honor. Hold on just a second. Let me get.
Yeah, this is the case. So someone from your firm sent a proposed default order, which was fine. It tracked the dollar amount, the liquidated dollar amount that he owes. That's documented. It was just the attorney's fees piece, as in what's not the big amount, as in what he owes Bell and Washington, but what he would owe ultimately Bell and Washington for the work your firm did for Bell and Washington, if that makes sense.
Absolutely, Your Honor. And that's just time associated with trying to get him to pay, receiving no response, filing this matter, those things.
Okay. Got it. And do you have any documentation for that, or how do you want to prove that up?
I can get an invoice and submit it to you. Is that okay?
Yeah, if you want to get an affidavit that says, here's our billing, these are reasonable rates and a reasonable amount of work done. The dollar amount figure is not alarming. That's not why I'm calling it out. I
understand.
We need to have it buttoned up. If Mr. Applewhite appears later on, he's got a right to understand where'd that $957 come from, or whatever it is.
Correct. Okay, so just submit it to you via email?
Yeah, send it to Ms. Niles. Whatever you would have presented this morning, if you were proving up the fees that your firm has billed Bell and Washington for the work done that they seek recovery for. Everything else is fine. You don't need to change that default order. I just need the documentation behind it.
Absolutely. And I apologize, I don't have it right now. I'm covering this unexpectedly for somebody who was on leave. So
okay.
I didn't have a time to get all that together because I learned of this at a very late hour.
Okay. Well, I appreciate you appearing. And like I said, we'll sort through it. You can just, as soon as you get that to Ms. Niles, then assuming it all checks out, I'll get the final default order out.
Thank you, Your Honor.
All right. See you. Yes, sir.
All right. Thanks.
All right. Position 4 is Cameron Homeowners Association versus the Toodles. Do we have anyone on for this?
Yes, Your Honor. Craig Cooper for the plaintiff.
Hey, Mr. Cooper.
And I have Mr. Richard Reed here, who's a client representative, if you'd like to hear from him as well.
Okay, I would like you to present whatever you think you need to present that shores up damages, the foreclosure, and attorney's fees. I've got a proposed order, but now's your time to put on before me what you want to.
Thank you, Your Honor. This is a case of unpaid homeowner association assessments, related charges of interest, late fees, and other charges, cost of collection, and which includes reasonable attorney's fees. This matter was originally filed December 17th, 2025. We're seeking a money judgment and a foreclosure order against the defendants, the Toodles. We're the record owners of 5295 Skidaway Drive, Alpharetta, Georgia. Both the defendants were served on January 13th. The affidavits of service were filed on January the 28th of this year. More than 46 days has passed since being served the complaint summons, so the defendants failed to file an answer. As a result, they admitted each and every allegation of our complaint. On June 27th, we filed a motion for default judgment, and which is currently before Your Honor. And Your Honor, I would like to testify as to the attorney's fees, if that would please the court.
Sure. I don't know about pleasing me, but that's great. I think you need to do that. So when you're ready.
Certainly. And we've attached to the motion for default judgment is the attorney fees statement, which is Exhibit A. My name is Craig Cooper. I'm an authorized attorney and have been since 2013. As of January 1st, my hourly rate as a senior associate at the firm is $3.50 per hour. And I did want to note that the affidavit is filed by Victoria Sand, who's currently out of the country, but I'm very familiar with this matter and am able to testify as to the attorney's fees. Nowak Howard has performed legal services on behalf of Cameron Homeowner Association in the collection of unpaid assessments and related fees. On behalf of the association, Nowak Howard sent the defendant notice of its debt and the association's intent to collect, its intention to foreclose on the statutory lien, filed the lawsuit, perfected service, and prepared and filed the motion for default judgment. Legal services described, not including attorney's fees for today's hearing, have resulted in unpaid expense to the association of $2,165 in attorney's fees and $224.60 in expenses, cost of collection, and $258.25 in court cost. Again, the itemized statement is broken down on Exhibit A, which is attached to the motion. In addition, there's a full accounting of the amounts applied to the defendant's account, which are shown on our Exhibit B to the motion. These amounts are detailed in that statement. This statement is a business record for the firm, and it's within the regular course of business for the firm to make and keep such records. The entries appearing on the statement are made at or near the time they are incurred, made by or from information transmitted by someone with personal knowledge and a business duty to report, and subsequently reviewed for accuracy. The hourly rates were performed, time spent, and total expense incurred for legal services rendered in connection with this case are reasonable, usual, and customary in light of the nature and complexity of the work involved. And these fees are actually incurred by the association.
All right. And I've got that affidavit in front of me, so you've covered that. We've got in your brief in support of the motion all those other figures you cited. Anything else?
We would just request an additional half hour for preparing for and attending today's hearing as well, which is $175 in addition to the figures that we've stated already.
All right. That would mean, I guess, unless it's in, I'm having trouble opening a few documents this morning on this machine. We have a proposed order, but I suspect that those figures just can't open the file right now, track what is in your brief. So unless you've already incorporated that extra half hour, which seems reasonable, then you'd need to submit a revised default order to Ms. Niles.
I'd be happy to do that, Your Honor.
Okay, well, if you get that sent to her, she'll get it to me and we'll get it out the door.
Sounds good. Your Honor, may I be excused?
Sure. Mr. Reed, anything you want to add? It was great having you here. You've been nice and quiet. Nope, you're good? Okay, have a great weekend.
Thank you, Your Honor.
Bye-bye. All right, now we have Marriott International versus Bottomline Solutions.
Mitchell Lovett here for Marriott International, Your Honor.
All right, Mr. Lovett. So let me tell you what I understand is going on here. Bottomline had an event at the Marriott Marquis and spent a whole lot and didn't pay. That part is real clear to me. The part I wrestle with a little bit is service, and I'd like you to help me get comfortable that whatever was done to serve this Bottomline Solutions is not a Georgia corporation. So service is a little different than what we normally see, and I'm pulling up the docket here. Talk to me about how you understand service worked and why you think that's sufficient. Since you're seeking a default judgment, no input from Bottomline.
Right, Your Honor. Let me pull up service. I thought you were going to ask about the attorney's fees.
Oh, well, we'll get there. First is service.
Your Honor, we use Georgia Code 14-2-504, which permits service via mail, certified mail. And that's how we served the defendant in this case.
Okay. Hold on 1 second. Sorry, I'm full service shop here. I had to let the cleaning crew into the office. No one else is here.
I understand.
All right. So 14-2-504 authorizes service by way of certified mail, and it looks like things were sent to this address in Brentwood, Tennessee.
Yes, Your Honor, which was the registered agent of the corporation. And there was, I don't know if you're aware on your end, if you can see this, that this is actually kind of the third instance of this dispute because service was becoming such an issue in attempting to perfect service. And so the service was made many attempts before using service under the statute here.
Okay. Where would I see that?
Let me see. Your Honor, I would have imagined that it would have been in the case.
Yeah.
File on your end. I didn't handle the service myself, but like I said, I do believe that the case was dismissed for lack of service and then refiled. I thought it was reopened, but it looks like a new instance of the case was opened, Your Honor.
Okay, got it. I know there was an issue in this case because I had to issue the order saying, look, this has been sitting here. You need to serve, and you did. But what you're saying is that this particular case ending in 1675 might well be the second iteration of Marriott versus Bottomline Solutions.
Yes,
Okay.
and Your Honor, if you'd like, I'd be happy to address any other issues that you have about this, and then get back with you with maybe sending the chambers a detailed kind of outline of the methods of service that were attempted prior to using 14.2504.
Okay, let me look at 14.2504. Yeah, I guess we'll need to take a look at that, because the way I read 504 is that if the corporation has no registered agent, and here you believe there is one, Mr. Nelson Griswold, you've got his address. If there isn't one, you can serve by certified mail or overnight delivery. Or if the agent cannot reasonably or with reasonable diligence be served.
Right.
And that's the part. So they do have an agent. So it would have to be that your client tried really hard to serve Mr. Griswold at Hearthstone Lane in Brentwood, Tennessee, and that just didn't work out. And so you may have record of that, but I don't see that in the docket.
Right. Your Honor, would you like me to pull those together and then kind of file a notice with the court in this case that outlines the service attempts made on this?
Yeah, we don't need to reconvene in this format as
Right.
long as what you submit is sufficient. What we should iron out now is, yeah, dang, those are crazy attorney's fees. Is the amounts owed, and if those are all buttoned up, then it would just be me concluding that the service was statutorily sufficient.
Yes, Your Honor. I will. I'll get those together and I'll just file a notice with the court that outlines
Okay.
the service attempts.
All right. Okay. So let's talk about the damages.
Yes.
Well, you'd be the one talking about them. I'm the one listening
I'm
about
sorry.
them.
Yes,
Okay.
Bottomline Solutions, as you stated, Your Honor, it held an event at the hotel for goods and services had and received. It racked up a $309,000 bill. Marriott contracts for group events like this have a clause called attrition, wherein both parties agree that if there's underperformance on the room block or the amount of goods and services, then and a liquidated damages amount would be owed. That number is directly tied to the underperformance and the room rate. So if I was going to have 1,000 rooms, but I only had 800, then I may owe attrition on a percentage of those unused rooms, which is just the room rate. And so for Section A, the compensatory damages are the goods and services had and received. Section B, the liquidated damages are directly tied to the contract's attrition clause, and it's the underperformance on the contract that the parties mutually agreed to, so it's liquidated. And then Section C is the attorney's fees, which is based on the contingency agreement that Marriott has with Rudner Law Offices.
Okay. Let me look. Okay, I was just looking at attachments to the complaint, which is where you get to all those numbers. Okay,
Yes,
got that. So that explains the the $309,000, big number, because they didn't use all the rooms that they asked Marriott to set aside, et cetera. But then we've got these bonkers attorney's fees that would seem like you worked on this case for 10,000 hours.
You're right, and to be frank, that's wrong. Typically, when we have a dispute like this, which has gone to just to a default, and there hasn't been a lot of work in the case, when the contingency amount would be such a grand number, what we would do is we would instead state the amount of hours that we worked on the case, and what our hourly rate is, with the understanding, and the law supports that we would just receive 25% of, from our client side. And so if I may propose, what we do is when I file my notice of service attempts made on the defendant, I also include in that a more streamlined attorney's fees, which instead states the amount of hours worked on the dispute at the hourly rate, and we pursue that approach instead.
Okay, I'd prefer that. I appreciate you offering that up. So 2 projects for you, and if what you send in is sufficient, then we don't need to reconnect on Zoom. One, just whether it's an affidavit of the service agent, or whatever it is, that documents the attempts to serve the registered agent in Tennessee, because if there were efforts and Mr. Griswold was never there or wouldn't answer the door, then it does look like that 142504 authorizes as a fallback the very way you did provide service. And then project 2 is to do what you just described with the legal fees.
Yes, Your Honor. Absolutely.
All right. I appreciate your flexibility there. If you will email that information to Ms. Niles, she'll get it to me. It may be that after I look at it, I ask you to file a couple of those things just so our docket is robust and has in it what we talked about. And you make sure 1675. I've got the default order. I can substitute the number in when you present the attorney's fees that are grounded in fact. And so you don't need to submit a new default order.
Yes, Your Honor.
All right. Anything else?
No, Your Honor. Thank you for your time.
You too. Have a good weekend.
Bye. You too.
All right, we should have left just 2 cases. One is with Dr. Newbie, and I have seen her on the screen. She is there. Is there Falcon Conley somehow with like 1 minute left said, "Hey, I've got a lawyer now." Are you Ms. James? Hey, Ms. James.
Would you like me to approach just to ensure that Ms. or Dr. Cree can hear me?
In a minute, I'm just taking attendance. So we've got everyone we need to talk about Dr. Newbie's situation. And then the other matter is, I think it's Ms. Liberace. Okay, Ms. Liberace versus Slutty Vegan. Is there anyone on the call for that? All right, so Ms. Liberace, am I pronouncing your last name correctly?
Yes.
Great, so we've got everyone we need for your situation as well. So we're going to start with Dr. Newbie because now I'm going back to numerical order. So let me get Dr. Newbie on the screen. There you are. And then Ms. James, if you would come, you can pick either table. Doesn't matter to me. All right, we've got plenty of cameras there so people can see each other. So let me tell you where I think we are with this, and then I'm actually going to start with Ms. James after I talk a little bit, because there is this motion to open default that just hit, and I want to engage a little bit on that. Then we'll pivot back to Dr. Newbie and talk about her situation. So Dr. Newbie had an apartment. It was unit D5 on Conley Road. And I think ultimately, because of a failure to pay rent, and if I get any of this wrong, your screen doesn't say Dr. Newbie. Am I saying it the wrong way?
It is Dr. Newbie, Dr. Asir Newbie. I'm sorry, Your Honor. That was already in there before I logged into the Zoom.
Oh, it's all good. I just didn't want to be calling you the wrong thing.
No, you're fine. Thank you.
Dr. Newbie voluntarily vacated the unit, and she thought, hey, we've moved on. Her pleadings indicate that she got the green light from, and I may get the titles wrong, but the property manager who says this place looks so clean, it's like no one lived here. It was good to go. She left nothing behind, and she had moved on in her own direction. And then one of the parties on the defense side, and only one remains because I dismissed a couple of parties for failure to serve. But regardless, there was a dispossessory, a writ of possession that issued, but the unit was vacated already. And I think there was an effort to collect some money as well, because allegedly there was some bulk property still there, and suddenly the unit wasn't in tip-top shape. But as I understand from your complaint, Dr. Newbie, the main concern is, hey, I left, we sorted these things out, and now all of a sudden, and this is my word, not yours, there's this stain on my credit history. There's this writ of possession. I look like a deadbeat. I look like I got evicted. And that's not how it played out. That's hurtful. It could be potentially damaging. It's not what was supposed to happen. And so you filed this suit. And you actually did successfully serve Falcon Conley's registered agent. And nothing happened. And so then you move for a default judgment. And that's what we were going to do today, is talk about that. And just a few days ago, Ms. James appeared on the scene and has alleged through an affidavit, not that the registered agent was not served, but that the registered agent didn't do his or her job, and that somehow Falcon Conley never got word of this lawsuit. And there's an affidavit from someone from Falcon Conley saying, we didn't learn about it, despite having a registered agent. I've never run into that kind of situation before, where a registered agent allegedly didn't do its job. So it's a little peculiar. And of course, I've got no information from the registered agent saying, oh yeah, we didn't do it. I don't know that the registered agent, in fact, didn't provide notice, and Falcon Conley sat on it and now is saying, dang, we need to come up with a reason to reopen this. But before we even wrestle with reopening, really what we'd be talking about today, with Dr. Newbie representing herself and Ms. James representing Falcon Conley, is, but so what? Not about so what about the default, but these things happen. What is the remedy that is appropriate here? And to me, it seems like most plainly that I ought to enter something that wipes the writ of possession off the docket, so that if someone's doing a credit check or any kind of inquiry into Dr. Newbie, it's not there. Unless there's some reason it needs to be there. It sounds like it's not. It may have been taken out in error and right hand and left hand didn't connect, but I certainly want to hear from Ms. James on that. I'll hear from Dr. Newbie on damages. I'm not so sure we get to a whole lot of monetary damages unless something has already happened, and I'll need to hear about that. But what I saw in reviewing the docket as the most profound relief would be to get that writ of possession out of the system, which I certainly can do, and that actually doesn't impose any burden on Falcon Conley either. So those were my basic thoughts. Dr. Newbie, I'm going to start by letting Attorney James share a little bit about here's why I'm suddenly here and why you should buy into this notion that the registered agent didn't do its job. And then we'll just sort of take this one step at a time, okay? But I promise, Dr. Newbie, we won't suddenly end without you having had a chance to say, hey, I got to get this off my chest. That's part of what will happen this morning, okay? All right, it's James.
Good morning again.
Good morning.
Well, first, I'd like to start by introducing my client. It's a representative from Falcon Conley. This is Nick Dario. He's the one that signed the affidavit that was presented to the court.
Great.
And
All the way from New Jersey?
Yes, I flew in last night for today.
All right.
yes. So, Your Honor, our understanding is that although Dr. Newbie has presented service information, it was not properly delivered to the registered agent. It was.
Well, if I may explain, Your Honor, how it happened, they served in another attorney's office. InCorp is our registered agent. InCorp was not served. Someone else was served. And then allegedly they were supposed to forward it to InCorp, which I guess in all the translation lost its juice. However, we never got served. If the only thing that she's looking for is to take off the warrant, the writ,
of possession.
we would consent to that and leave it at that and end the case. However, if not, we did everything according to the law and we can prove that.
All right, those are big words. Let me see what we've got in the docket.
InCorp is our registered agent.
I hear you.
Thank you.
All right, so what I have in the docket here, what is in the docket, is a entry of service from the sheriff indicating that Falcon Conley CV20 LLC, that's basically you, Mr. Dario, was served at Suite 500 at address on Roswell Road. It names the paralegal who accepted it. And what you're telling me, not as the paralegal or as the service agent, is this tale that Ms. Johnson, the paralegal, is actually a paralegal with a different firm, and she was going to make sure that that service went to your service agent, and it didn't.
That's correct, Your Honor.
And you know all this how?
I was on the phone when I found out about the case at the beginning of the week.
How'd you find out about the case?
Our property management company, Royce, that was already dismissed for this, for the reasons we're
For
gonna.
non-service.
Yeah, for non-service.
Right, but they were dismissed months ago.
Right.
And so how did the property management company, just a few days before we were going forward, decide now's the time to tell you that there's a lawsuit?
Because that's where they found out. We're in the middle of another lawsuit for a shooting. And I guess when they were on a computer going through getting documents, they bumped across this and said, hey, Nick, you better take care of it.
Okay.
Your Honor, I did everything I possibly could. Secondly, if we can, the service, in my opinion, went to one party to another party and never made myself.
Okay, so your affidavit says something different. Your affidavit says my registered agent didn't give it to me. And now here in court, you're saying my registered agent never got it.
No, okay, I never received it. Whether my registered agent received it or not, I never received it.
Okay, well, you're sharing multiple stories with me. Let me turn to Dr. Newbie and hear from her. One, how things are going. It sounds like you found a new place. But two, Mr. Dario has indicated, and it's really not his call, it's mine, that he doesn't object, and it really wouldn't matter if he objected, to having the writ of possession stricken. I don't know the right legal term, but I would make it happen so that that goes away. Tell me, Dr. Newbie, beyond that, what you think is the appropriate outcome here and why.
Your Honor, thank you, Your Honor. This has been a journey since the eviction was first filed. The eviction was filed, let me go back to the eviction. The eviction was filed last April, and it was filed because of the crime that was in the neighborhood at 875 Conley. I had just moved in. I was given a different representation of the property. And I have a witness, if she should be on here, Brenda Melton. She's a former deputy sheriff of Fulton County. She came to visit me and she was offered drugs. So I had went to the office continuously complaining. I decided to let the eviction file go to court, and I filed a counterclaim. I had a lease bond on the apartment, and that bond covers the amount of rent in the event of default or damages. Okay, so I was under the impression that after the counterclaim, after the hearing, after Attorney Andrew Jaweski and I agreed that I could move out and there would be no further problems. So I cleaned the apartment. I videotaped myself with the apartment being cleaned, and I had one of Falcon Conley's representatives walk through the apartment with me. He indeed stated that the apartment looked spotless as if I never lived there. I moved out thinking that everything was fine. Prior to this, I had no health problems. I did not suffer from anxiety. I did not suffer from any stress. When I got the notice from the guarantors saying that I owed Falcon Conley for damages in the amount of $676.55, I was alarmed. And so I began to email back and forth, and the guarantors sent me pictures of damages in the apartment. They sent me pictures of a chair, of a bed. And I went back and forth with the guarantors. The representatives for Falcon Conley was refusing to send the money back. By this time, the claim had already been paid.
When you say send the money back, I'm confused, meaning you were trying to get your security deposit back?
No, there was a claim stating that I damaged the apartment, and that claim was paid out to Falcon Conley from the guarantor's insurance.
Okay, got it. And that's the $678.55 that.
Yes.
Okay.
And so what happened going forward? When I got that, I was already in the situation. I didn't know where I was going to go. I had this eviction filed. I see that there's a writ of possession. Now the insurance company is saying I have to reimburse them the $676.55 that they paid out to Falcon Conley.
Okay.
They fought that. The insurance company fought against that and sent over the video that I had taken of the apartment being clean that didn't coincide with the dates that the pictures showed. So they knew that something was off. The apartment complex, Falcon Conley, then reimbursed the insurance company back their money based off of that. And in return, I've applied for an apartment. I could not get an apartment. I could not get an apartment because not only of the eviction, but the writ of possession. And I tried to explain it several times. I ended up moving into a pad split, which is a rooming house. I started having panic and anxiety attacks because I didn't know where I was going to stay, if I was going to get approved, because the laws in Georgia, and I'm sure the attorney James, she's a property manager, can coincide with this, that when your credit report is pulled, the main three credit reports is Experian, TransUnion, and Equifax. But not all property management companies pull that. They pull public records. And there are hundreds of public record agencies that pull from court documents. They don't ask what the outcome is. They don't give you a chance to explain. They'll just say, we see that there was an eviction and a writ of possession filed. Okay.
Let me ask you a few more questions, and then if there's more you want to share, I'm happy to hear it. So the $678.55, did you ultimately have to reimburse the insurance company for that?
No, the insurance company decided that they would drop that. That once Falcon Conley paid them back, they dropped that against me. But they did come after me. I do have a piece of paper where they were about to come after me for that.
Okay. But that one's closed out.
Yes.
Okay. And then also in your complaint, you talk about a $500 charge for the removal of bulk items and $125 charge for move out charges or cleaning the unit. So that's $625, different amount of money. Did you end up having to pay that?
No, sir. They waived that as well. Once I showed them that I filed a civil suit, they agreed to not have me pay that.
Okay, and they would be Falcon Conley, or
would be the guarantors.
Okay,
the bond insurance company.
Got it.
So the way that it works, Your Honor, the way that it worked for me, I can only say what worked for me. When I went to apply for the apartment, there was a apartment manager, Willie Vargas. Willie Vargas told me, well, because you had not too long ago filed bankruptcy, a good way that we get our tenants in here is to have them file a lease bond, rental bond insurance on their apartment.
Yep.
And so I agreed. And
and that's who Ms. Prudent is. She was with the guarantors, and so she's the one with whom you were interacting about the $678 as well as the $625.
Yes, that is correct.
And you are out of pocket $0 for either of those two amounts.
Yes, sir. That's correct.
Okay, good to know. All right. And you look like you're in a place now. You eventually found a place?
So Brenda Melton, she is one of my witnesses. She should still be on. She can attest that I have bounced from hotel rooms, having to pay for hotel rooms. I've been in and out of hospital with anxiety because I didn't know where I was going to go, where I was going to stay. Should I spend money to apply for another apartment and get rejected and lose my money? What was I going to do? I stayed on her sofa. I ended up in the hospital back December 8th. All of this was stressful. So the place that I'm at now, I've only been here a month, and it just so happened that there was a woman I talked to, and she needed help with she needed me to do some help with her, helping her out with some things, and she allowed me to have a room here. And so I paid her $1,000 a month just to stay here.
Great. Well, I'm glad that you landed something like that. And I hope it is in a neighborhood where if Ms. Melton came to visit you, someone wouldn't offer to sell her drugs as she's walking up to the front door. Okay.
So it's been a lot emotionally, Your Honor. It's been a lot.
I hear you. And I appreciate your candor on that. All right. Thank you for that information. That helps fill in a few areas where I was less clear. So Ms. James, I'd like to turn back to you. I know you're an attorney. You're also a property manager?
Not.
Okay. But you represent firms that are involved in property ownership and management.
Correct.
Okay. So what do you want to add to the mix? And I don't know if Mr. Dario has been, I know he's been whispering in your ear, as he should. He's the client. If you see a way, it sounds like everyone is aligned with getting the writ of possession off the docket because, of course, Ms. Dr. Newbie is not still in the unit. So that's a pretty moot one.
I'm not one for that anymore.
Correct.
I want to present our evidence.
So, Your Honor, just to add a little bit more color to
Mhm.
some of the things that Dr. Newbie has stated, the reason for her needing to have the bond for the unit when she first moved in was because she'd already had a previous eviction. And so we needed to have some security that it wouldn't happen again, but it did. So it wasn't just the bankruptcy. She had prior poor credit that required that. The amount of money that was then waived or paid by the bond company, especially regarding the large items that had to be removed from the property, that was unrelated to the consent judgment that Dr. Newbie signed when the eviction occurred. The eviction occurred for non-payment of rent. The landlord then has 30 days after the tenant moves out to file for damages to the apartment, trash out, any of that. So again, it was charged but then removed. So there's
Charged then removed, meaning there were charges applied saying, Dr. Newbie, you owe X because of A, B, C, and D. But ultimately, A, B, C, and D, you know what, we're just going to clear the ledger. So are you, that this adds additional clarity. It's not that the guarantor had to pay out any of those amounts. It's ultimately that Falcon Conley said, we're just going to eat this.
Yeah, exactly.
Don't worry, Dr. Newbie, I'll come back to you.
The guarantor actually paid the rent that she didn't pay, and that's the
Okay.
only thing we accepted.
Right. So, but as far as
It would be helpful if I could testify.
Sure. Can we have my client testify? 'Cause he was,
Yeah, I mean, we can't, what I'm trying to avoid is diving too deep into this
Right.
because I think I see some of the fundamental disagreements. And really my question was, we know about the 678.55 and then there was a 625. And I had taken from Dr. Newbie that the guarantor ended up paying those amounts and then just said in the end, we're not going to pursue it with you, Dr. Newbie. But it may be that that was a miscommunication and that the guarantor didn't end up paying anything because Falcon Conley said, it's just, let's move on. The apartment has been vacated. We can release it. And so we're going to move forward with getting a new tenant in the apartment.
correct. But I think the major issue here is Dr. Newbie stating that her inability to rent because there was an eviction on her name.
Oh, you're pointing out that there would be others. If one ran, I don't know what you call it, a credit check or a renter background check, that this wouldn't be the only writ of possession that would pop up.
Correct. Not only that, but the fact, I do have a copy of, and I also filed it as an exhibit to my motion, but the consent order and judgment states that she should have been out by April 3rd by the end of the day, April 3rd. There were large items that still remained in the property, which showed that she was still in possession of the property. And so that we still had the right to file for the writ of possession on the 4th. Now, I'm not sure how well you know what happens with magistrate court or how long it takes for those cases to go through, but
I've heard.
Yes, so I handle them all the time. It could take months.
Yep.
So by the time you file the writ of possession, it could take weeks before the judge signs off on it.
Yep. And in those intervening weeks, the situation on the ground changes.
Correct.
Okay.
And so what happens is once the sheriff receives that writ of possession, they have to mark it somehow just to clear it out.
Mhm.
And in this instance,
They
the
marked
sheriff-
it vacated.
They marked it vacated
Right.
because she had vacated by the time they wanted to go and execute it. So
Yep.
the thing that really damages tenants as far as future rental is if it's marked as ejected. It was not marked as ejected because she was not ejected. They
She
never
was
had-
not. She had already left.
Correct.
Okay.
We communicated with the sheriff's office. You all do not need to come out. She's vacated. And so they had to mark it. But we did have the right to file that writ of possession on the 4th because she still had items in the property on the 3rd, and she has no actual damages that are the fault of Falcon Conley. We never charged her funds or actually required her to pay any funds for the items that she left or the unpaid rent. And any type of issue that she's having with alleged mental health or anything like that, that's due to no fault of Falcon Conley.
Did you represent Falcon Conley or any of the other parties at the dispossessory hearing that resulted in the consent order from the magistrate?
I did not.
Okay. All right.
One more thing.
That's also helpful context. Let me turn back to Dr. Newbie because she raised her hand, and I know there are always two sides to every story, and it's helpful to get all this information. Dr. Newbie, what did you want to add?
I just wanted to clarify because I know the attorney just came on a couple of days ago, as we noticed on paper. Let me clarify because she was not at the original hearing. At the original hearing, I was able to show that I was already in the process of moving out. So those items that they're claiming that was there, the reason why the guarantors gave the money back was because of the simple fact that I did move out. In fact, Falcon Conley, one of their employees, came to the apartment that day, and the young lady upstairs needed a bed. I gave her my mattress. I have a $3,000 bed, Your Honor. That the pictures that was sent to the guarantors was pictures of a chair, as if somebody had stayed there, and with a chair, a black microwave, 2 mattresses on the floor inside the apartment. When I left the apartment on the 3rd and turned in my keys on the morning of the 4th, because the office was closed, I turned in my keys. I was no longer in possession of the apartment, nor did I have any keys to the apartment, because that was a part of me leaving, was to be able to turn in my keys. And all of the stuff that was there, they showed on the picture, which I do have a copy I can send you of all of the pictures that were sent by the guarantors.
She turned the keys on Friday.
Do differ from the date of my video. There is no way possible, Your Honor, that I would clean out an apartment just to come back into the apartment. And that was the argument I presented with the guarantors that made sense. So that's why the guarantors went back and said, no, we need our money back.
Okay.
And then finally paid them their money back, which I do have in an email showing proof that they did have to pay them back. So it was paid, the claim was paid out, and then it was paid back. As far as my stress, my alleged stress comes from this.
Okay. I'm going to ask you a question. I want to be very clear. I'm not ever wading into the field of severity of stress. That's very personal, and you experience it. I don't. And this has to have been a taxing situation, to say the least. So I'm not minimizing that in any way. Ms. James indicated that her research showed that you might have had writ of possession in a different, an earlier scenario. Do you agree with that?
I did. I did. That's when I was filing the bankruptcy.
Okay.
So I did have a bankruptcy. I did have to give up the apartment in a bankruptcy. And
Okay.
I did have the insurance, but I wasn't told that the insurance was because of the bankruptcy. She stated I was told that. She wasn't there. I was not
Okay.
told.
Understood. So you had flagged bankruptcy. You used the B word, but included with that was a writ of possession. That was all part of an episode you went through before renting this unit on Conley.
Mm-hmm. Yes, sir. Yes,
Okay.
sir.
Got it. Okay.
Your Honor.
Give me 1 second and I'll pivot back to you.
She said she turned the keys on the 5th.
Yeah, you took the keys.
Yes. So it was filed on the 4th, which puts us in every right to file it. That's why I said we're not going to withdraw it anymore. We'll leave it now. You don't want to take the deal. The 3rd was a Wednesday, the 5th was a Friday. It's a doctor.
It's kind of.
The charade.
All right, Ms. James, I'm sorry to keep you waiting.
No worries.
That-
Just one last statement regarding the timeline. Again, the consent agreement stated that she should have been out by the 3rd. She turned in keys on the 5th, which is our record, as well as what she states in her original complaint is that she turned in keys on the 5th and then took a video on the 5th. So we had every right to file this writ of possession based on the fact that she still had possession through the keys, as well as still having property inside, personal property inside of the real property.
In your experience doing this kind of work, if a client is running a credit background check and bumps into writ of possession, do they typically take the next step to say, oh, but that was writ of possession vacated as opposed to writ of possession ejected? Or do they just see writ of possession and that's the mark of Cain? Like, oh, already alert, we're going to need a guarantor, or we'll just say no thank you because we've got 3 people kind of jockeying for this apartment and this guy, he's got a writ of possession. Does that question make sense? Because it's sort of a second layer of meaning.
Yes. I mean, to be honest, I'm not sure. I think that they just, I think if a writ of possession is filed and they see that the sheriff actually had to come out and remove them, that's generally what I tell people when I'm making these types of deals in the courtroom. I say, hey, you need to make sure that you're out. You don't want the sheriff to come and mark that you have been ejected, because the next landlord does not want to know that I'm going to have to go through all of that to get this person out if they fail to pay.
Got it.
So I think that they do look at it, and that's usually what I tell people.
So you've had situations where you saw that the writ of possession resulted in a vacated, and so you are saying that's not great, but it's less bad than writ of possession ejected.
Correct.
Okay. All right. That's helpful. All right. So Dr. Newbie, I know that you have Ms. Melton here. It sounds like what she would say would corroborate what you've already told me. And so I don't mean to preclude her or for you to think that I didn't let you have her talk with me, but if she would be amplifying what you had to say or corroborating it, I don't feel like I need that. I feel like you have given me lots of helpful context to what was going on, and then also importantly, what has gone on for you since then. Is there anything else you want to share?
No, sir, Your Honor. They just keep saying I left stuff in the apartment when I did not.
Okay. All right.
Oh, I just received a text message from Willie Vargas, who worked for the company. I asked him to be on, but he was in therapy today as well. But Mr. Vargas was, of course, he was let go just like some of the other witnesses that I tried to get in contact with. But he was the actual one that walked with me through the apartment when I got the apartment, recommended the insurance to me. And Mr. Vargas can attest to everything that I said as well.
Okay. Got it. Well, I hope he's doing okay. You said he's in therapy, so I hope he's all right. Ms. James, is there more that you want to share with me, or do you feel like through your pleadings and Mr. Dario's information he's been able to share? And I appreciate you coming all the way from New Jersey. That's not right next door. You've shared with me what you think I ought to know.
Yes, Your Honor. I mean, I think the dates all line up to show that we have the right to file the writ when we did. Filed it on the 4th. She turned in keys on the 5th and still had property there. So
Okay.
well within our rights.
Okay, I appreciate all that. So Dr. Newbie, here's what's next. I will take under advisement everything I've heard today, hearing from the actual people involved. So meeting you and hearing from you was real important. And I want to repeat, I'm glad to hear that you are, for now, in a safe space, that you are able to afford, and that you're sort of paying it forward by helping the person who's provided you the room. So that's great. And I will get an order out. If I need additional information, Ms. Niles will reach out to both sides. There won't be any ex parte anything. So I think, Dr. Newbie, we've got a good email address for you. Is that correct?
Yes, sir.
Good. All right. So if I need more information, then even if it might be from Ms. James, you'd get a copy of that email. So you could say, well, hey, wait, let me tell you what I think about that as well, or vice versa. If I needed more information from you, Dr. Newbie, Ms. James would know what that request is so that she could chime in and say, well, think about this piece as well.
Okay. Thank you, Your Honor.
I have one last question that I made a note of last night when I was reviewing this. Did Falcon Conley pay costs? You filed a bunch of things. Has it paid costs?
No, we have not. We can go down to the clerk and pay what needs to be paid.
Okay. You're going to do whatever you think is the right thing. I don't know how to find that in the system, but that is a component of a default situation. Okay. Sounds good. Well, thank you, everyone. If no one else has any questions, and Ms. Melton, I never got to see you, but I appreciate you being on the call as well. All right. Thanks, Dr. Newbie.
Your Honor, thank you so much.
You bet. When are you flying back? 10 minutes?
Right now.
All right.
Thank you. I really appreciate it.
Thank you, Your Honor.
Have a great weekend.
You're welcome, Dr. Newbie, and you're welcome, Mr. Dario. You should stay for the All-Star game.
Oh, is that this weekend?
Well, it's Tuesday, but the HBCU game is tonight, and the home run derby is Monday, and then you can watch it. It'll be on TV. But
Yeah, Beyonce in town.
I know this is
Beyonce's in town.
Atlanta is the hub.
It certainly is. I'm leaving Sunday for vacation with my daughter.
All right, well, enjoy all that.
Have a good weekend.
Thank you, Your Honor.
You're welcome. Take care.
Thank you.
All right, last but not least, Ms. Liberace, if you want to come on up, and you're welcome to sit. If you want to sit, you can come to the podium, whatever is easiest. How are you today?
Good.
So, the way I understand it is that you used to work for the Slutty vegan outlet or operation at Spelman.
Yes, sir.
And you were terminated. You are alleging that that was based on age discrimination, it was a hostile place to work, et cetera. You're not quite sure why they didn't let you back on. I guess it was part of termination. I want to start by asking you how you served the company. And I know you're not a lawyer, so if I need to explain a term, let me know. I'm not trying to talk past you ever. But services, you let them know I'm suing you so that they have a chance to say, oh, well, I'm going to ignore it, which is sort of what's happened here, or I'm going to get a lawyer and respond, or I might just respond. I don't have to have a lawyer. Actually, they would have to because you sued a business. And businesses need lawyers to actually move forward with something. So tell me what steps you took to let the restaurant know you were suing them.
Well, Your Honor, on February the 20th, I I came down here to Superior Court. I filed a civil lawsuit
Mhm.
against Slutty Vegan,
Yep,
for age discrimination.
yep,
And, on March the 3rd, the sheriff served Slutty Vegan.
okay.
Mhm.
You gave him an address on Edgewood. Is that the Spellman place where you worked, or is that corporate
That's
headquarters?
corporate. That's the
Okay.
main.
That's the main place. And, excuse me, is there also a restaurant there? Or what, if I went to 476 Edgewood, what's there?
It's a restaurant, but it's the main location where everything get like done, like human resource.
Okay.
So it's human resources in that building.
Okay, so it's also kind of an office. And I could go there and order a burger,
Yes.
a vegetarian burger,
Yes.
but also somewhere there'd be a desk with a computer where they keep corporate records and things like that.
They have, okay, so here's the restaurant,
Hmm?
and they have, the human resource right across the street. So, they use that address for, dealing with stuff like, if anything have to come through, they have to come through that building.
Okay,
So they use that address.
got it. And so that's the address you gave. That's where the sheriff dropped that stuff off.
Yes.
Okay, had you ever heard of the person who received it was named Justice Philemon?
Mhm.
That's someone you knew?
No,
No.
I know that, I heard that he was a manager there.
Okay.
Yeah.
You heard that just from when you were working at the Spellman one, or you heard that it says manager on this piece of paper? That's how you learned it. Okay. All right. Well, talk to me about your situation and what you think your damages are. If they owe you for wages that you didn't have, and let me actually take a step back. When did you work there?
I've been working for Slutty Vegan for a year and some months, but that new location, I only worked there for like, a month
Okay,
at Spelman.
got it. Where were you working before?
I was working at the other Slutty Vegan on Edgewood.
The one where they ended up serving Mr. Philemon.
Mhm.
Okay, so you'd been with the restaurant company for over a year.
Mhm.
Did you ask to go to Spellman, or did they say, hey, we're gonna move you over there?
I asked to go to Spelman because I thought I was gonna get a different treatment, but it was the same treatment with age discrimination.
Okay. So you thought new space, new place, new shift managers would be a better situation.
Yes, sir.
It wasn't.
No.
Okay. All right. Well, talk to me about the treatment, and then let's wrap up with what you think ought to happen as a result of what occurred.
Well, the treatment that I encountered at Slutty Vegan was age discrimination. I was the oldest one there, and they had a lot of younger people that was younger than me. So they put me in the kitchen in the back, and they put all the younger people in the front. And many times I had requested to not be back there, and they refused to put me up front because of my age. And I was not.
I'm periodically, I'll interrupt just because I'm curious or I might not understand something. You've now said several times, they did this because of my age, they did that because of my age, which is not okay. What makes you felt that way, or did they just say, you're old woman Liberace, we don't want you up front, we need one of these young women or men at the cash register, and you're washed out, so go back and make the food?
Okay. Not only me, but I observed the place. I was doing observation, and I noticed that all the older people was in the kitchen and all the younger people was up front. So that's the observation of that.
Mhm.
That's how I came to that.
Okay, so it wasn't explicit where they said, all right, everyone over 35, you go back there. Everyone under 25, you go up there.
It was like, it was jokes.
Okay.
They made repeatedly jokes. They would call me auntie,
Okay.
auntie, get back there in the kitchen,
Yeah.
And they like, they were just saying derogatory, slang words towards me.
And when you say they, it would be management, or it would be the younger employees in front, because they're not your boss.
It would be, the younger employee and manager.
Hold on one second. Hey, good morning. Are you dropping clothes off? For Mr. Holliday, perfect. You can leave them with that deputy right there. He'll get them to Deputy Gordon and we'll be all set. Thank you for doing that. Sorry, we have a criminal trial on Monday and the guy's in custody, so he needs street clothes. So he looks sharp for the jury or doesn't look like he's in jail. All right, so, but it was management that would say, auntie or things like that, get back in the back.
It was manager and in the regular employees.
Okay.
Both.
All right. Was the pay different? If I ran the cash register, did I get paid more than the person in the kitchen? Or it just was, it's hot and dark and stinky back there and it's nicer up front? What's the difference?
The pay was different. The people in the front, we didn't receive the tips in the back, but the people in the front, they received tips plus the pay.
Okay. And tell me what you understood the pay. I understand tips. That's a variable, but you didn't get any of that, only the folks in the front. What did you make on an hourly rate in the back?
It was just $11 an hour.
And what would you make in the front?
You probably, $11 plus tips.
Okay, so the flat rate is the same. If on Tuesday, no one tipped at all, and you work for 5 hours, and I'm at the cash register, and I work for 5 hours, we get paid the same. But if the tips are $700, then I'm getting a cut of those tips, and you get big fat zero.
Yes, sir.
Okay, Deputy Gordon, Mr. Holliday's clothes are right there in that white bag. Okay, and you requested on more than one occasion, could I please get up to the front? And we're told no. Okay, was there some kind of special skill in the front, like you had to be able to juggle and you don't know how to juggle, or you had to use a kind of knife and you didn't know how to use that knife?
Oh, no, because that's basically what I was doing in the back, using the knife. It's because they wanted all the older people in the kitchen and all the younger people up front. And that was the very reason why they was doing that.
Okay. And they never told you that, but you don't have to be a dummy to figure that one out, is what it sounds like.
Well, they would do a little side jokes about us, the older people in the back. You know, like their way of telling us, like, y'all old people get back in the kitchen, you know, like joking.
Yeah.
That's the way they was telling us. Don't come up here.
I'm never supposed to do this, but I need to talk about age. The people up front were what age range? You don't look like you're particularly old. If you were to tell me, Judge, I'm 28, I'd say, wow, okay, that unsurprised me. And it's harder to understand age discrimination if you're only 28 and the guy at the cash register is 26. That's a narrow range. But if the guy at the cash register is 5 and you're 80, that's more obvious. So what kind of ages would you put on the people who had to stay in the back? Y'all old heads versus.
It was 40 and up.
Okay, so you are 40 and up?
I'm 44.
Wow, I would not have guessed that. Okay.
Oh, thank you.
Sure. So the old heads are 40 and up. They're in the back making everything. And then people in their 20s are the ones, the shiny faces saying, welcome to Slutty Vegan.
Like,
how can I help you?
17. I think the oldest least was about, they weren't even 25. So it was 25 and under.
Okay.
Up front.
All right. So let's talk about what kind of relief you're seeking. I can't get you your job back, but you lost your job, and I don't know if you're working again. I hope you've got another job, but in the interim, you weren't working. So what kind of damages are you seeking?
Punitive damage. It's just for the wrongful action that they did, neglecting, wrongful termination. Then they retaliate against me.
How so?
On February the 20th, I complained. I got the text message, all the message I have on my phone. I complained about age discrimination. To my manager, Toya.
At the Spelman location?
Yes, sir.
Okay.
And I have that text message. I complained to her. And because I was new at the other Slutty Vegan at Spelman, the manager had more credibility than me because he'd been there the longest. Nobody knew who I was. Yes. So therefore, she when I complained about the age discrimination, she immediately just believe what the manager say. And I was ignored. Like everything that I said was ignored, neglected. As you can see today that they're not here. Like they even neglected the court order when you ordered them to be here. And it's like everything is ignoring and neglecting and
Okay.
not responding.
Yep.
Same
Okay.
behavior.
All right, but tell me the retaliation part.
Okay, on February the 20th, I complained about age discrimination. Okay, on February the 24th, I got fired right after I complained about that.
Did they say, well, we fired you because you made everyone sick with the vegan burgers, or what was the explanation for you getting fired?
There was no explanation. I got text message on why, what happened, and no response.
Do you know what it means to be an at-will employee versus someone with an employment contract? Is that?
No, sir.
Okay. You were working at Slutty Vegan. Did you have a contract that you signed, or?
No, it's just regular, no, just like I went there and got hired.
Okay, you had an interview and they said, great, it'll work. You're going to work in the kitchen.
Exactly.
And you were at the Edgewood place for a long time and then said, let's try it out at Spelman.
Yes, sir.
Okay, so you were fired the day after you complained. Was that the first time you had complained about the age discrimination?
Yeah, that was the first time.
Okay, and you're fired the next day. They didn't give you any explanation.
Yeah, it was 4 days later. I was, yes, and they didn't give me any explanation.
Okay.
Mhm.
I think you said in your complaint that like they barred you. Like, did you try to go back to work and they said, get out of here? Did they call the police? What happened?
Spelman police, yes, sir. I was on the line while the manager, he was attacking me. He was saying all these type of slug terminology. He was very thuggish like. He was coming towards me because I came up front, and that's the very reason why he was attacking me, because he, like I was telling you, they was telling the older people getting back, you can't come up front. So I said, my job duties is to work the whole place. So I came up front. So therefore, because I came up front to work, that's when the attack came.
So this is a little different. I thought you said that you complained about the age discrimination and then you got fired. But it sounds like in between there.
I'm just telling you the behavior. I'm going like in details, like the behavior on the job.
So when was it that you said, you know what, I can work anywhere in the restaurant, I'm coming up front, and the manager said, you better not?
That was that day, February the 20th.
Okay, and he said, you can't be up front, you gotta be in the back. And that's then when you made the complaint to headquarters?
That same day.
Okay, it wasn't after you made the complaint that you, because I'm trying to, if I'm wearing the manager's hat, I'm like, who is this lady? Her job is to work in the kitchen, and now she's up front saying, I don't want to work in the kitchen, I'm going to work up front. Like, you don't get to decide that. I'm the manager, I get to decide that. So it sounds like you guys butted heads a little bit on that.
Yeah.
I don't mean physically, but you had a disagreement.
Yes, sir.
Did you go back when he said to go back?
Yes, I went back.
Okay. Would that be a reason why you got fired?
You talking about going there?
Going up to the front, saying, I'm not going to work in the back anymore. It's almost like you're going on strike.
I can say that the reason why I got fired is because I complained.
Okay.
Complaining got me fired.
Not I'm going to protest and try to work up front.
No.
Okay. All right. So damages, we have to try to quantify them. Talk to me about what you think a fair outcome is. And don't say $100 million, because that's not, sometimes people get in here and they see dollars and they're like, I've been wounded beyond belief, $100 million.
No, of course, this is a very low paying job, so it's very low.
But it's your life, and you were mistreated and discriminated against for something that you don't control.
Right.
That you were 44, and there's nothing wrong with being 44.
Yeah. So,
Okay.
are you asking like the amount or like, to describe like what's in damage?
Well, both, because in the end, if I do an award, the award could just be, this was wrong and Ms. Liberace was mistreated. Shame on you, Slutty Vegan. And that may make you feel whole again because you were heard and a judge said Slutty Vegan mistreated Ms. Liberace. That will not put a nickel in your pocket. And that may not be what you're looking for. You just want closure and vindication is the word we use sometimes. Like, yeah, someone heard me and someone else said that's not the way to do things. Most people come in wanting that and a little bit. And so I don't have any sense of whether you think, I should have been still working there and that was in April and here we are in July. And I mean, this case is older than that. And I haven't been able to find a job. Those are the kinds of things people point to is I've been out of work. I was wrongfully terminated. I couldn't work. And so I'm owed $11 an hour times 100 hours gets you to X or whatever it is. So I don't know if you've been thinking about that at all.
Okay. But thank you for giving me the insight, helping me to think. But yeah, it will at least be about 40,000 because if you add it up, I could have been still making future pay if that would never happen. I could have been still there. And my behavior before that is I never had a problem. They never had a problem with me or nothing. It was just the age thing.
Mm-hmm.
So I could have been still working there if they would never discriminate against me because my age. So because of the future pay, what I could have made, I'm asking for that.
Okay. Are you working now?
Yes, sir.
What are you doing?
I'm a caregiver.
Okay. Does that pay more than $11 an hour or less than $11?
Less.
Less than $11 an hour? Gosh, you're doing more important work.
I know.
Okay. Are you with a company or it's just Liberace caregivers?
Oh, a company.
What's the company?
Homestead.
Okay. And does that mean you go into a home and provide care for someone or you're at a assisted living facility?
Goes into a home.
Okay. How many hours do you work?
I work 3 hours. 3 hours.
3 hours a day?
Mhm.
How many days a week?
Let's see, Monday, Wednesday, 3 days.
So you're making less per hour and you're working fewer hours right now. Have you tried to get a job in the restaurant business since you were at Slutty Vegan, or you're done with that, which is why you're doing home care now?
I'm done because it was just so hurtful. I went home, I cried. It's like when someone is powerful and you're like nobody to them. It's like they take advantage of that. Like,
Yeah.
who are you? You can't do nothing. I dare you. Who you think you is? No one gonna believe you. You're poor. That's the type of behavior they gave me.
You said she. Who's the she?
I'm going into when I contacted the owner because I was so hurtful. I contacted Pinky Cole.
Yeah.
She's are you familiar with her?
Yeah.
Yes, I contacted her. And she even just kept pushing it off and laughing at it and making jokes. And she was doing similar things that the employees was doing. And when I was telling her, are you going to allow them to move me? And you have the authority and the power to say, what did she do? And because she was in neglecting that, she had the authority to tell the people, no, she didn't do nothing wrong. She just doing her job. Did she fight you? No. Did she cuss you? No. What did she do? She only doing her job. And she had the authority to tell the chef, do not remove her. But because she neglected and she didn't tell them to stop, that's the reason why I'm here. And it was so hurtful, so embarrassing to get removed from a place that you're working at, and you didn't do nothing wrong.
You described one incident where someone who's just watching from the outside, if I had been at the restaurant that day when you said, I'm moving up front, and the manager's, you can't come up front. I told you need to work in the back. Someone who's neutral on all this might think that Liberace's kind of nuts. She's showing out. She's saying, you got to let me work up front. Were there any other instances that someone could point to where it would be Ms. Liberace was acting out in a way, and I don't mean to suggest you were acting out. You were asserting what you felt was your right to, I should be able to work not just in the back. Let folks who have some experience be up in the front of the restaurant as well. But I could also see how someone would characterize that as insubordination. Were there any other instances like that where you were trying to express yourself or assert your rights where a manager might have thought she's crossing the line?
No, sir, there was no other incident, but it's, I got hired actually for a cashier.
Really?
Yes, that's why I was reacting like that. I asked on my application, it said cashier. So
Okay.
but
Meaning day one, back when you were at the Edgewood location?
yes, sir.
Okay.
And because I thought that I was gonna be working up front, when I got there, it was a different story. It was like, no, they looked at my age and they said, you're working in the kitchen. And I was like, but you guys hired me for a cashier.
Yeah.
So, yeah.
Okay. All right. Are there other things you want me to know?
It's just the neglecting, like, it's like they don't respond to nothing. Like, when I complain about discrimination, not responding. When you guys sent the motion of default, not responding. Like, I just want you to know that the humiliation I had to go through, them removing me for nothing that I did wrong. And I had a good reputation on the job. When people, you say my name, they be like, who? Oh, that's the lady that always smile, and that's the lady that always making peace with people. And it hurted me because they destroyed my reputation too. Because I had a good name there, and they just destroyed my reputation to make it look like something that it wasn't. And it was just so humiliating and just embarrassing and shameful.
Do you know if, I know that this business has struggled a little bit recently. Do you know, is the Edgewood store still open? And is
It's
this
still open. She got a business back.
She got it back?
Yeah, that was
Okay.
just she have it.
And the Spelman one is still open?
The Spelman one is closed. She reopened a new store called Bogey.
Yeah.
So yeah.
Okay.
So yeah.
I know that she was going to try to open one at the airport, and the airport's like, I can't rely on this. And so it's not going to be at the airport. It'll be something else. All right. Well, Ms. Liberace, I'm glad you found some other work. It doesn't sound like it fully replaces the income that you were earning through this job. So I'm sorry for that. Hopefully you'll find something else soon or get more hours doing the home health care. Okay. Any questions about anything?
No, sir. I just would like for you to grant me this motion.
So I'll take that under advisement, and I need to enter an order. It'll be a final order in the case that says, here's what we're doing with this. Now you were, I think, e-filing things. So you get things in the email when there's a notice in this case, you get an email that says, hey, something's happened in the case?
Yes, sir.
Good. Well, that's how you'll know, is that I'll enter the order. So you'll get an email saying you can click on it and see what it says. Just so you understand, if I end up awarding you a judgment, it's not like there's a check attached to it. It's a judgment against the business. And then you need to figure out, how do I turn that judgment into actual money? That may involve talking to a lawyer or researching it online, but a judgment from a court in favor of someone doesn't have the money attached. It gives you a right to get that money from that person, that business, whatever it is. Okay? Any questions?
No, sir.
All right. Well, I appreciate you being here. I appreciate you pursuing your rights.
All right, thank you so
and I
much.
hope you have a good weekend, okay?
Okay, you too.
All right. Take care. Yes, I can end this Zoom now. We're right on schedule. All right. Let me see. There's no one else on here. So we'll end that.